Courts try to interpret contracts to effectuate the party's intent. But what if a literal reading of a contract's terms seems like nonsense? In Beanstalk Group versus AM General, the Seventh Circuit considered whether a contract really meant what it said. AM General manufactured and sold Hummers, a civilian vehicle based on the military's Humvee. General contracted with Beanstalk Group for Beanstalk to obtain licenses for General's Hummer trademark. Beanstalk received 35% of the gross receipts under any license agreements executed while the contract was in effect. The representation contract defined a license agreement as, quote, any agreement or arrangement, whether in the form of a license or otherwise, granting merchandising or other rights in the property, unquote. Property included the trademark and related rights. Subsequently, General entered into a joint venture agreement with General Motors, or GM. Under this agreement, GM would design and engineer a new version of the Hummer and finance a new factory to manufacture it. As part of the agreement, GM acquired the Hummer trademark. GM didn't assume any of General's obligations under the representation contract. Beanstalk sued General and GM in federal district court for breach of contract. Beanstalk alleged that the joint venture agreement was a license agreement under the representation contract. Therefore, Beanstalk claimed it was entitled to 35% of the consideration that GM paid General for the trademark. The district court granted General's motion to dismiss the complaint for failure to state a claim. Beanstalk appealed to the Seventh Circuit.